has been pending before Judge Stutzman, and he's had several hearings in this matter. Judge Stutzman is a circuit court judge.
In the face of chaos, justice rises. Truth has no fear.
Wait, how did a simple zoning issue turn into arrest warrants? What's really going on here?
Are the Yoders here? Somebody filed something. Did you get a copy of this, Lance?
I did. Somebody handed it to me, but it was not the Yoders that handed it to me.
Okay. Well, I just got it a minute ago. So, all right. Well, it is the appointed time. It's 2:02. Let me call these cases. Get them set out here. There are matters in two separate cases before the court. Oh, yes, thank you. Everybody may need to scooch down. There are two separate matters before the court here today. And there are several things that we're going to need to address. The title of the cases, for starters, is Colon Township versus Joanne Yoder, which is 25533CZ, and Colon Township versus Alfred Yoder, which is 25533CZ. There is a preceding case, Colon Township versus Alfred Yoder and Joanne Yoder, which is in file 252040CZ. In 25040CZ, there is a permanent injunction in effect that was ordered by Judge Stutzman earlier this summer in July. And the defendants were compelled to appear at a show cause hearing, and they failed to appear. And Judge Stutzman issued bench warrants for their arrest. The way I read the petition is for civil contempt, set bond at $1,000 cash in each case. I believe last Friday, I found out about this on Monday. The defendants apparently presented themselves at the jail on August 22nd, posted $1,000 cash bond in each case, and were given a notice to appear for today for the show cause contempt in file 25040CZ. Plaintiff Colon Township has filed a brief in support of a motion for preliminary injunction, actually requesting a permanent injunction, and file 25533CZ. These are two separate parcels of property. 25040CZ is 30158 Marsh Road. I believe the property known as Mama's House, which has been in operation for some time. The second case, 25533C, CZ has the same addresses, but it is a different parcel of property very near the other property road.
It actually has a separate
All right.
address.
Adjacent to-
30246.
What is the number?
30246 Marsh Road. Is the 533 CZ case.
All right,
Now, the Yoders live at 30158.
All right.
That's their address.
this is adjacent. All right, now preceding all of this, all right, we'll get a little background. This matter has been pending before Judge Stutzman, and he's had several hearings in this matter. Judge Stutzman is a circuit court judge, and this matter was filed for hearing in the circuit court. Judge Stutzman made some rulings and issued these 2 bench warrants. Sometime after the bench warrants were issued, I was assigned by the Supreme Court to hear this matter. Judge Stutzman has disqualified himself for reasons that are known to him. And he asked me, he actually called me while I was on vacation and asked me whether I would take this case. And I said, yes, I would. So Mr. Thornton has filed a motion to, I guess, reassign me or disqualify me under the theory that I should have been assigned to a circuit court judge. And so we have to deal with that before we do with anything else. Once the order of disqualification was entered, Judge Stutzman signed it, Judge Pattison signed it. I don't remember whether Judge Kane did. I had already agreed that I would take it. Mr. Thornton, you're aware of this. St. Joseph County is part of a concurrent jurisdiction plan. That was entered on January 16th of 2013, and I'll provide you with a copy of that. And the concurrent jurisdiction plan indicates that the benches will share obligations. There is a statute, 600.8304, regarding jurisdiction. In a district court district, which the district court is affected by a plan of concurrent jurisdiction adopted under Chapter 4, the district court has concurrent jurisdiction with the circuit court or the probate court, or both, as provided in the plan of concurrent jurisdiction. So just before you folks all came in here, I did a personal protection order matter, and I've done dozens, maybe hundreds of them. Those are circuit court matters, and we are all cross-assigned under our concurrent jurisdiction plan, and all 4 judges actually do personal protection orders. And I do my share, and I had one just a few minutes ago. On a number of occasions, I have covered circuit court matters in criminal disqualifications. I'm the primary backup for Judge Stutzman if he has a case in which he has to disqualify himself in a criminal case. So those are felonies. I've handled a number of those. I'm also his primary backup in zoning cases. And he's had several occasions over the years where he's had to disqualify himself in zoning matters. He disqualified himself in Lockport Township because he lived very near where the property at issue was. Recently disqualified himself. He moved to Fabius Township. And they had a complicated matter regarding solar farm. And he was disqualified. And I was assigned by the Supreme Court and our chief judge to hear the matter. So Mr. Thornton has cited some of the case regarding that, but Mr. Thornton, I do not believe it would require that I not be eligible to handle this case. I'll ask you if you have any other comment, but it's my intention to deny your order to reassign a judge. What would happen is it would then go to the next judge, who would be Judge Pattison or Judge Kane, who would know even less about this than I do. But I don't feel like I know less. As you know, we do lots of zoning cases of all shapes and sizes. And so It's my intention to deny your motion, but is there anything else you'd like to place on the record?
I appreciate the court providing me with a copy of the concurrent jurisdiction plan.
Do you have one yet?
I do.
Okay,
I
yes,
do.
I would think we
Have
sent
that.
that.
So, not sure I agree with the whole concept, but I understand the law. I've read it and read the concurrent jurisdiction plan. I understand it and understand that it provides that this can happen. Before Your Honor actually rules, though, I would just like to inquire because it does appear that Judge Stutzman said he had a conflict. Judge Pattison has indicated he has a conflict, had some knowledge or had spoken with the Yoders or their friends or both. On behalf of the township, I would just ask if Your Honor feels like there's anything that he knows or has been introduced to that would cause a conflict for Your Honor in this matter.
Well, that's a fair question. In the last case, I represented that I was going to dinner at Farron Hall shortly after our hearing. That was an issue that I raised myself. The answer is no. I know very little about this. I was at a county commission meeting when a number of people got up and spoke at the commission meeting about this issue. And that was the first I even heard of it. I don't know any of the parties. I know very little about it. I have not discussed it with Judge Stutzman, other than when he called me and asked me whether I would accept the assignment. So no, I don't know the facility. I've never had a case involving Mama's house to my knowledge. I don't know Joanne Yoder. I don't know Alfred Yoder. Lord knows I would be more than happy to foist this off on another judge down the line, but I don't feel I have justification to disqualify myself. So for the record, I don't know the parties, know very little about the case. In fact, I was totally uninformed when the parties were at the commission meeting speaking about it. I asked my administrator, she had some knowledge of it. But
if you were in their place, would you face the judge or skip court too? Be honest.
So the answer is no.
And I accept that. And so I'll just let the court make its ruling on my motions.
All right, I will do a formal order denying your motion in each case. So that's our first order of business. Our second order of business is to deal with the bench warrants. Because I didn't know anything about this case, I had to familiarize myself with the file. And so I spent some time going through both files, 25040CZ and 25533CZ. Things are mostly done in the 25040 case. Judge Stutzman entered the judgment of permanent injunction on, I can't read it, March 13th, I think it was. So that case has been decided. However, there was a show cause and then there was another show cause. And he issued 2 bench warrants. And then I was confused because the bench warrants were issued by Judge Stutzman and the clerk on, I believe it was July 7th. And the Yoders were personally served by Sergeant Morse from the Sheriff's Department later in July. At the time they were served of the notice for this hearing, they were open bench warrants for their arrest. And I had a question of why weren't they arrested when they were served with the warrants? And I don't know that I got an answer to that. I don't think they wish to have a confrontation. I think there'd been some discussion about having them present themselves in the warrant, but a sheriff's deputy had personal contact with the defendants while the bench warrant was in effect, but it was not served.
My understanding is Bruce Morris doesn't conduct arrests anymore.
He does not, but he would. He doesn't. I don't want to. He does a wonderful job for us, as
Yes,
you know.
he
He
does.
handles our service, and he makes my life much easier by being so competent and professional. But at any rate, he is still deputized by the sheriff's department. Anyway, so eventually the Yoders presented themselves at the jail on Friday the 22nd. We're given notice to appear today, and they're not here today. They posted $1,000 cash bond, each of them, and filed 25040. And there's a notice from the sheriff to appear today at this time and date, which is good because we were already scheduled to be here today at this time and date.
I wasn't aware that anything had been set for today for that particular issue, but
Yes, let me see. I think I copied the notices. They were given notice by I can't read the deputy's name. I guess I saw the original copy for August 29th at 1400 hours, failed to appear on the show cause. So they aren't here now. A number of other people are here. So I can't arraign them on their bench warrants because they aren't here. Someone was here earlier this afternoon, and these were signed and date stamped August 29th. I received what I is entitled response and filed 25040 and 25533CZ. So the allegation is that the defendants were in civil contempt for failing to appear for an order to show cause, and now they failed to appear pursuant to a posted bond for an arraignment on the show cause. Mr. Thornton, what's your thought in that regard?
my thought first with the responses that have been filed today, as the court has pointed out in 25-040 CZ, there really isn't anything to respond to in that. So I don't know what the court wants to do with that. With the response today attempted to be filed in 25-533 CZ, the
Well,
Yoders
let's stick to 40 for a minute, because that's where the bench warrants are.
okay.
I'm unhappy that they're not here. I never met them. I don't know them. I don't have any prejudgment about it. Judge Stutzman issued those bench warrants. There was criminal or civil contempt. My inclination is to issue a bench warrant for criminal contempt for failing to appear pursuant to a posted bond and set bond at none. No bond until I see them. They will appear at the jail or be arrested by the sheriff and be held in custody until such time as I can conduct an arraignment. I don't like somebody poking me in the eye with a sharp stick. Judge Stutzman ordered the bench warrants. They did appear and present themselves. They posted $1,000 of cash in each case. Civil contempt is punishable by up to $7,500 in fines, but not a criminal punishment. Now they failed to appear pursuant to this. Now, this is a civil contempt in a zoning case. The Criminal Justice Reform Act changed the rules a little bit as to bench warrants in criminal cases. As a rule, we are to give 48 hours of grace before the bench warrant issues in a criminal contempt case. Fail to appear on a bond. And so my inclination, Mr. Thornton, is to issue 2 new bench warrants with no bond until they're seen by a judge, namely me. And give 48 hours. In fact, I would start the 48 hours on Monday. So they'd have until 5 o'clock on, well, Monday's a holiday. I would grant them until.
So tell me, are the Yoders rebels standing up for their rights, or lawbreakers pushing their luck?
O'clock Wednesday, September 3rd to appear.
And I'm fine with that, Your Honor. In that case, as the court's pointed out, we do have a permanent injunction. The birthing center is not supposed to be in operation, and it's my understanding it is still being operated.
We haven't taken any testimony regarding that, but that would violate the permanent injunction and subject them to further contempt if it is still being operated. Anyway, I'm going to issue a bench warrant for Alfred E. Yoder for failing to appear pursuant to a posted bond in a contempt matter. I'm going to set the bond at no bond until such time as he sees the judge. He has until Wednesday, September 3rd to present himself at the court. I would order the exact